And get started, folks. Hello, everyone. Welcome to the Fort Bend Chamber of Commerce's Business and Professional Division webinar. I want to thank you all for taking the time to participate in today's event. My name is King Banerjee. I'm a small business owner here in Sugar Land, and I'm also this year's division chair for the Chamber's Business and Professional Division. For those of you unfamiliar with the Chamber, or for those of you who just want to join me in celebrating, we are proud to be the only 5-star accredited chamber in the greater Houston region. As the advocate for excellence in Fort Bend County and beyond, the chamber serves both our business partners and our community as a whole. While I couldn't be more proud of being associated with the Fort Bend Chamber, I'd be remiss if I didn't take this opportunity to thank the chamber staff, led by Carrie Schmidt, to include Stacy Bynes, Juliet Nesmith, Ryan Husted, and of course, Paige Talbot. Before I introduce our speakers, I would like to tell everyone just a couple things, in particular about the chat feature. If you have any questions, please feel free to type them in the chat dialog box, or if you're watching this on Facebook Live, please type them in the comment section, and we will address those questions after the presentation. At this time, I have the very distinct privilege and honor of introducing our speakers. Mike Dobert with HR and Alignment, LLC, and Justin Markel with the Roberts, Markel, Weinberg, Butler, and Haley Law Firm. First, Mike. Mike is the owner and principal of HR and Alignment. Mike has over 28 years of experience of human resource and business strategy experience with senior professional human resource certifications to include SPHR and SHRM SCP certifications, as well as additional certifications in diversity, leadership, and change management. Aside from being an all-around great guy, which he is, and an even better friend, Mike supports our community by serving as past president of the board of the Cullinan Park Conservancy, as well as donating his time and services to various other area nonprofit agencies. Mike also served as the 2016 chairman of the board for the Fort Bend Chamber of Commerce and continues his service to the chamber just as he's doing today. Not to be outdone, Justin Markel is an equity shareholder attorney at RMWBH Law, practicing in the labor and employment and corporate transaction sections of the firm. Justin advises and counsels employers regarding various employment law issues. This includes drafting employment policies and contracts and counseling employers regarding issues relating to employee requests for leave and accommodations and allegations of harassment and retaliation. Justin is board certified in labor and employment law by the Texas Board of Legal Specialization. Justin was also selected the Texas Rising Stars for 2015 to 2020. This is a peer designation and it's awarded only to a select number of accomplished attorneys in each state. The Rising Stars selection process takes into account peer recognition, professional achievement in legal practice, and other cogent factors. So, without further ado, please help me welcome Mike Dobert and Justin Markel.
Thank you, King.
Thank you, King.
I'll go ahead and pass that to you, Mike.
Okay, I think what we'll do, Paige, if you want to bring up the PowerPoint, and then Justin will take the first piece of it. We'll share some thoughts, and then I'll take some of the later subjects. And again, we'll complement each other with some thoughts there to make sure we've given everybody the information, and then we'll see if we have time for questions. If not, you can always follow up with us.
All right. Well, I guess thanks so much, everyone, for joining. I'm really glad to talk about what's happened since really last year when we gave a presentation about new employment laws in the wake of COVID and kind of the latest and greatest practice tips for employers in this kind of new normal that we find ourselves in. If we could go to the next slide, I've got a really small disclaimer. I'm a lawyer, and so of course I have to give one. So the information provided in this presentation is educational and informative, but if you're looking for any specific advice as to your specific situation, I would encourage you to reach out to either a lawyer or an HR professional, because your unique circumstances might give rise to different advice. So kind of every situation is different. Go to the next slide. So what are we going to be talking about? First off, where we are now in comparison to last year. I'll touch on what's happened to the Families First Coronavirus Response Act since its original enactment last April. I'll also touch on the state of current sick leave ordinances in Austin, Dallas, and San Antonio. And then I'll touch a little bit more in depth on mandatory vaccination policies. I tend to get more questions about that topic than really anything else these days. And then I'll turn it over to Mike, and he'll talk about moving forward in 2020 and beyond. What are we seeing across the country in terms of trends in employment law? And then also, like, what are we going to be expecting under President Biden in terms of initiatives and things like that? If we go to that next slide, please. Okay, so the Families First Coronavirus Response Act, where are we? The law was enacted last year, and it had a sunset provision the end of 2020. There was some talk in Congress about possibly extending that through 2021, but it didn't really get off the ground. The only thing that really ended up getting passed was an extension of tax credits. So where are we on this statute? So right now, employees are not entitled to leave under the statute. Essentially, the employer requirement to provide paid sick leave and expanded family medical leave under the statute is gone. As we sit here on February 3rd, 2021, I'm sure in Mike's piece we'll talk about potentially it might return. And so essentially right now it's a tax credit statute. So employers can give Families First Coronavirus Response Act leave on a voluntary basis, and employers are able to get tax credits for that leave so long as that leave is provided before March 31st, 2021. But what does this mean in terms of administration? It kind of leaves open a lot of open questions. I think for sure we can say that employees are not entitled to any more leave than they were granted when the statute was passed originally. So if you remember, the paid sick leave portion of the statute provided for 80 hours or 2 weeks of paid sick leave for 6 different reasons. You don't get a new 80 hours or 2 weeks in 2021 if you're an employer that's going to be providing this kind of leave on a voluntary basis. Similarly, for the expanded family medical leave portion, there was an entitlement to up to 12 weeks for being at home, unable to work because your kids are at home because their child care provider is unavailable or their school is closed due to COVID reasons. You don't get an additional 12 weeks in 2021. But in terms of how much leave an employee could take, if an employee is in an employer that is going to be voluntarily providing that leave, kind of an open question. I would tend to think that, for example, if an employee took this expanded family medical leave for 8 weeks and didn't take any other FMLA leave in 2020, then if the employer is willing, the employee might be able to take 4 additional weeks through March 31st, 2021. But it also kind of depends on what your FMLA policies provide for, because when you assess a request for FMLA leave, you have to look at whether the employee has worked 1,250 hours in the last 12 months. You have to look at whether or how much leave the employee has in their bank. And that kind of depends on what your policies say. Some employers will go on a calendar year basis. So the 12-week leave entitlement for FMLA runs on a calendar year basis, and you kind of re-up for 12 weeks on January 1. Other employers, I think probably the majority of employers that I see, go on a rolling 12-month basis, which means that you assess how much leave is left in the tank, kind of on a looking 12 months backwards from the anticipated leave date. So kind of a lot of open questions as to how you would administer that voluntary FFCRA leave. I also get questions about, since it's voluntary, can I just provide paid sick leave and not expanded family medical leave, or vice versa? That's kind of an open question. I think textually the statute allows you to do it, or I guess the expiration of the statute allows you to do it. But we don't really have any specific guidance from the DOL on that. So I guess I would tread carefully. Another question is if an employee takes expanded family medical leave on that voluntary basis in 2021, does that count against other FMLA leave entitlements in 2021? It's also an open question. We don't really have any specific guidance, and I've seen attorneys in the employment bar go both ways on that question. So I guess hopefully we'll receive more guidance from the DOL, assuming that the statute just doesn't get re-upped as a whole. So I guess stay tuned on that. If we could go to the next slide, please. So that takes care of where we are on FFCRA leave. In terms of the Texas leave ordinances, the last time we gave this presentation, I had a couple minutes on the state of some ordinances in Texas that required paid sick leave. And at the time, the Dallas ordinance was about to go into effect. And so it kind of played a factor in the analysis of whether to allow certain employees leave for certain reasons. I can say right now, we don't really have to worry about that as of today, because all of those ordinances have been enjoined. And at least in the Austin case, the Texas Supreme Court refused to hear the case. And so that effectively ends that case, which means we know for sure that the Austin ordinance isn't going to be really effective. So don't worry about them for now, but I guess for now is the key language there, as I'm sure Mike will touch on in a bit later. If we go to the next slide, please. Okay, mandatory vaccination policies. I get more questions about this nowadays than really anything else. And so the number one question is, can I require my employees to get a vaccine, a COVID vaccine? The answer is generally yes. And I'll say the answer was a little uncertain before really recently when the EEOC came out with new guidance on this. And so under that new EEOC guidance, and we'll link to it in a slide later, under that new guidance, employers are assured that mandatory vaccine policies are generally okay. And that really stems from the guidance's statements regarding medical examinations. The Americans with Disabilities Act regulates whether and to what extent an employer can engage in a medical examination. Essentially, that's questions that are usually in a medical setting, but not always, that seek information about an individual's physical or mental impairments or health. And so that definition is pretty broad. And so it was kind of an open question as to whether requiring a vaccine was essentially requiring a medical examination. The EEOC has come out and said, no, it isn't, which basically means that as a general rule, employers can require COVID-19 vaccinations. There are important caveats to that, which we'll get to in very, very shortly. But before I get to the next slide, there's a couple of things to note here. Although requiring a vaccination is not a medical examination, it's generally advisable that if you're going to require employees to get the vaccine, that you basically require them to get it from an unaffiliated third party. You generally, as an employer, don't want to be the one administering the vaccine. And really that's because before you administer the vaccine, you've got to ask some clearance questions, and those clearance questions probably count as medical examinations. And so, if you don't want to be in the position of having to go through the analysis of whether this medical examination is consistent with business necessity and job related, you would just require them to get it from like a third party like CVS or Walgreens. Those are not medical examinations. Kind of a similar question, can I require proof of vaccination? The EOC confirms that generally, yes, you can. But again, be careful that you're only asking for proof of vaccination, and that you're not really asking any other questions that might require an employee to divulge health information or information about physical or mental conditions. If we go to the next slide, please. Okay, so what if you require a COVID vaccine for your employees, and one of your employees comes back and says, well, I've got a disability and my doctor says that I really shouldn't. What's the analysis? And the new guidance from the EEOC goes into really a lot of detail on this. But the general steps are outlined on this slide. First, you would do a direct threat analysis. So basically, you would have to determine on an individualized basis whether having the employee unvaccinated would pose a substantial risk of harm to either the employee, him or herself, or to others in the workplace. And there's some factors to consider here, but at the end of the day, we're really asking whether the unvaccinated employee is going to be exposing others in the workplace to COVID. And so you can imagine what that kind of analysis would look like. If you eventually conclude that there is a direct threat there if the employee remains unvaccinated, then the EOC says, well, then you go through an accommodation analysis and you engage in an interactive process with the employee, which is basically a discussion with the employee about is there a potential accommodation here that would reduce the risk of harm to an acceptable level? Or are there other, are there other ways to work this out? Can we require the employee just to continue remote work? Is the employee entitled to leave either under the Families First Coronavirus Response Act on a voluntary basis, or under the FMLA, just kind of classic FMLA, or other paid sick leave policies? And when we evaluate accommodations, is it going to be an undue hardship? Is it going to impose an undue hardship on the employer? And basically what that means for non-lawyers is that going to result in a significant difficulty or expense? And then, the EEOC also provides other factors to consider in determining whether there's an accommodation available. And I guess some of these kind of surprised me, but some of those factors are how many employees do you have that are vaccinated? So essentially like trying to evaluate the risk of exposure to employees based on whether they've been vaccinated. Other factors I think kind of make sense, like how much does the employee have contact with others? Are they just in an office alone, or is it like a customer-facing business where the employee has to have contact with a lot of employees and a lot of people from the public? Factors like that just should be considered in determining whether there's an accommodation. And if there isn't an accommodation, then the guidance says that the employee could be excluded from the workplace. That doesn't necessarily mean termination. It could just mean extended leave or just continued remote work. But the EEOC eventually does say that if there's no accommodations available, then exclusion from the workplace is allowed. So that takes care of disability-related exceptions. What about religion? Some employees might have a religious objection to getting a vaccine. And here, Title VII imposes a requirement on employers to provide reasonable accommodations, so long as they don't impose an undue hardship. But in the religion context, the words undue hardship mean something different than in the disability context. So in the disability context, undue burden means substantial difficulty or expense. In the religion context, undue hardship means more than de minimis cost. So you could see a situation potentially where you would have to give an accommodation to a disabled employee, but you might not have to give the same accommodation to an employee who has a religious objection. But you would still have to engage in an interactive process. You would still have to figure out whether there are accommodations available, and I guess what costs go with those accommodations, in determining whether an exception has to be provided to the employee based on religious grounds. If we go to the next slide, please. So that's like the law on mandatory vaccination policies. But as a lawyer, I'm tasked not just with providing, what's the law on this, what do I have to do, but also to think about practical concerns. And, sitting here on February 3rd, 2021, right now we're in like phase 1 of vaccination distribution. And so it's only available in Texas to frontline healthcare workers, residents of long-term care facilities, people over 65, and people over 16 with certain health conditions. And if you don't fall into one of those categories, you're not really eligible for the vaccine right now. And so in counseling employers, I often ask the question, what's the use of the policy? If you're going to go forward with a mandatory vaccination policy, what's the use of it having it now if most of your employees don't qualify for a vaccine or aren't eligible? And I know that like it's always useful to plan ahead, but sitting here right now, what if you require everybody to get a vaccine and then a significant portion of your workforce just either refuses or fails to get it? Are you really willing? Are you really willing to be, put the hammer down and terminate that significant portion of your workforce over this kind of policy? I think in most cases the answer is no. And so, a better policy rather than a mandate might be just encouraging to get the vaccine. And I should note that before the EEOC came out with its newest guidance on this issue, the next best guidance from the EEOC had to do with flu vaccines. And under that guidance, it was the EEOC that was saying to employers, it's generally better to just encourage employees to get it rather than requiring it. And so it's just something to think about. So bottom line, you generally can require vaccines, but whether you should is a more difficult question. If we go to the next slide, please. So here we list some additional resources. The first bullet is the newest guidance that was updated to provide more guidance on the mandatory vaccine question. The second one is the pandemic preparedness guidance that sets forth guidance on flu vaccines, which is what I was talking about a minute ago. I've got my blog article down there, but something I wanted to spend a minute on was this OSHA link. OSHA has really just recently posted new guidance to employers. It was posted, I think, last Friday. And it's titled Protecting Workers, Guidance on Mitigating and Preventing the Spread of COVID-19 in the Workplace. It's a very, very long website. If you print it out, it's several pages, but it does provide in one place a lot of guidance for employers on how do you set things up and come up with pandemic preparedness plans to help make your workplace safe. It's something that I'm not sure that a lot of employers are aware of because it kind of went out without a lot of people noticing. But it is a really good resource if you're sitting there wondering, what are my obligations in terms of keeping the workplace safe. So that takes care of where we are now in comparison to last year. And now I'll turn it over to Mike to talk about where we're going.
Justin, thank you very much. You hit on so many key things. I know many businesses, small, mid, large, nonprofits, all types of organizations are looking at. And among the things that are important, not most important, but among those is the idea of a COVID vaccine. And what do I do with that? And so I echo some things I think Justin articulated where there is tremendous advice, keeping in mind that if you go the path of wanting people to take the vaccine, keep in mind religious and disability type discrimination accommodations. So whether it be a medical condition, disability, or somebody's religious belief, think about having a third party do it. Do you really want to get into the business of choosing which vaccine you're providing? And figuratively that they seem to be safe, but long-term. And so there's a lot of things you can do. And I think Justin said something that's very important as we continue to move on, is encourage. Do you mandate or do you encourage? And maybe you start with more of an encouragement. Maybe there's an incentive. Be careful about detailed medical records. And be careful about, do I terminate somebody that says, I'm sorry, Justin, I just don't feel comfortable taking the vaccine. I think in any group of friends, family, people have different perspectives. So great points, Justin. Thank you so much. As we move on, there's really three things we're going to talk about on the federal level. And the reason I'm going to emphasize the federal level is in Texas, we're still primarily looking more to the feds. Whereas, and we're going to talk about this, there are a lot of states, West Coast, and certainly the Northeast traditionally, and now you're starting to see Florida, you're starting to see Colorado, other states that are really starting to develop and really have in the past with California, some of those states, state level laws in regards to minimum wage and leave and a lot of different things. But for Texas, we're still looking primarily at federal. So there's really three considerations that we're going to talk about: paid sick leave and paid family medical leave. We'll talk about those. Wage and hour, minimum wage and salary threshold for exempt employees. And then what we're anticipating with the new administration, the Biden administration, is a very pro-labor, or I just say a pro-labor type of environment. I'm not sure, I don't believe this person's been appointed the last I saw, and something may have changed. But one of the individuals being looked at to head up the Department of Labor was the Boston mayor, or perhaps former mayor. So very pro-labor, pro-union type background and so forth. So there's just things to watch. So let's talk about paid sick leave. There have been, as I've mentioned, several trends. And for some years in California, for example, Washington State, the Northeast, Massachusetts, Connecticut, New York, and so forth. And as Justin alluded to, and that I have here, what happened in Dallas, Austin, and San Antonio, requiring employers to provide paid sick leave. Generally, and not limited to this, the consideration is if I work 30 hours, I get an hour of paid sick leave, sometimes up to 48 hours, sometimes up to 64 hours. So that's kind of the foundation we've looked at. Now, Dallas, Austin, and San Antonio, and Justin did a wonderful job to give us up to date on the Austin courts. But what I understand happened here is when these local entities started to mandate paid sick leave, if you're working in Dallas city limits, for example, or San Antonio, or what have you, the state and perhaps the feds, but the state said, well, hold on. Do you have the power to set forth basically wage and hour ordinances? That's really not up to the local entity or what have you. So we'll see what happens with that. And I think Justin hit on that, but here's really the key. And I'm sure like Justin, I have clients that are in California, these different states, as I mentioned. And so, okay, I may already offer paid time off that's inclusive of paid sick leave. I may offer vacation and sick leave separate. But I also, at least within Texas, have the ability to set forth rules. Do you use or lose it at the end of the year? Granted accrued, all these sort of things carry over. So that's going to be one of the considerations. If we look at it from a federal level, and my understanding, which may be right or wrong, is coming into the election in November, some of these things were on the table. How quickly they were going to move was one of the variables there. So for paid sick leave, there'll probably be some movement. As the current administration starts to set forth their cabinet appointees and so forth, they should be, well stocked, if you will. And so things should move rather quickly, but we may not see some of these things to 2022. We don't know. But it is scenario or contingency planning. So if this comes up, do I have a policy which provides that amount of paid sick leave or PTO that can be included for reasons related to this? The amount of paid sick leave, we looked at 1 to 30 up to 48 hours or 64 hours as some examples. We don't know at a federal level what they could do. Most of the states I've looked at have set forth rules that allow you to carry over up to a certain amount. Now, they may not allow a payout, whereas California for vacation considers it compensation. But there's a lot of things to be seen there. And what about small businesses? Is there going to be a threshold that says, Justin, if you're 10 or less employees or 5 or less, maybe it's a tiered progress that maybe by 2024, we'd like to see some of these things. Or maybe there's a state fund that mirrors and allows a small business that has employees to otherwise go that direction. We don't know. So it is something, and primarily I think we're looking at an audience for Texas today. It's a wait and see. It's something to think about. Review your current PTO policies, number one. And if you don't offer PTO inclusive of what could be used for sick leave, well, just have it on the side and think about what policy would you put in place. And again, the guidelines would be set forth a little bit more into the law as to the rules around that. So with that, let's go to the next slide, which is somewhat similar, but we're going to talk about paid family medical leave. And I think most people are aware, but it's good to kind of review the family medical leave. I believe 1993 is when it came into play. But it said, look, if you have 50 or more employees, and it set some parameters. Do you have 50 or more employees? If they're in separate sites, is there 75 miles between? And I've seen Department of Labor interpretations that said, well, you're a big enough company, regardless. Now, I realize some of our members and some of those watching may be small organizations, but it's good to set forth and remind us of the current family medical leave at the federal level. So I have 50 or more employees. They've worked a year, and that work a year piece, what happens if they've left and then came back? And so that question's come up with clients. And if they worked 6 months and came back and have been back 8 months, well, they've worked a year if there hasn't been more than a 7-year break, which is a very large break. So the reasons are, and what it allows a person to do is to say, look, within a 12-month period, I can take up to 12 work weeks, continuous, 2 different instances, whether it be full leave for pregnancy, for example, or intermittent reduced schedule, for a serious health condition of myself, a parent, spouse, or child, or the birth of a child, adoption, or foster care. Okay. And I've worked 1,250 hours. So that has been pretty clean. Essentially, what the Family Medical Leave Act has done, as it applies to those businesses we talked about, is, Justin mentioned it a moment ago too, it's within 12 months. Is that a calendar year? Is that 12 months forward from the date of somebody having a triggering event? Do I look back 12 months and see how much was taken and so forth? But it is job protected leave. So what has happened is, and this, where we're going to with this is, at the federal level, will there be a new requirement to say, on top of the existing family medical leave, now an employee should be paid? Keep in mind, most employers, and the law currently allows an employer to say, if I go out tomorrow for surgery, I start a 12-week counter. Employers can say, before it becomes unpaid and running concurrent, you first have to use, along with this leave, concurrent, your paid sick leave, your paid vacation, what have you. So what we've seen are state trends. And some of these have been in place for a little bit and have progressed. But again, your West Coast, your New England area states, and there's some others that are starting to trickle in and so forth. And some of those have said, well, hold on. If Justin, for example, wants to take parental leave in California, he certainly has the right to. Now, the question will be, who pays for that paid family medical leave? In some of these states, like California and New York, for example, it is, I have a 1%, for example, just a loose example, and those things can change sometimes, of a payroll deduction. It goes to the state piggy bank, if you will. And if I want to take that parental leave, okay, the employer is going to give me the time off, and I want it to be, if I want it to be paid, I'm going to go to the state and say, I'd like to be paid. And there's certain guidelines on that. Colorado, whereas they put in the paid sick leave we talked a moment ago into law this year, the legislative body has been charged with figuring out what's a paid family medical leave version look like in Colorado in subsequent years. So there's some traction there. Again, these state trends are starting to kind of come into focus for the federal level and to a lot of states that really haven't done a lot with these. Federal employees, is, if I'm clear on this, if I am taking leave for birth of a child, there's now a mandate associated with that. And here are a couple other things to think about we'll have to watch at the federal level. As I mentioned, do I have 50 or more employees? That's one of the criteria to say, do I have to offer the family medical leave? Well, California just lowered their version of the family medical leave, the CFRA or whatever, down to 5 or more employees. So again, that business in California may have to offer the leave. The person through payroll deductions is getting paid through the state. So there's things to watch here. And I reserve the right to be wrong, I don't think we're going to see dramatic things in this year that we may start to see in 2022 and go from there, but we don't know. We'll have to watch it together, as Justin mentioned. So with that, let's go to the next slide. I want to shift gears into some wage and hour considerations. And I think we've all seen this. Certainly there's some states, and I think we've seen a lot of things on the media and so forth with the current administration, the Biden administration. So keep in mind the federal minimum wage. And I'm not talking about federal contractor minimum wage. If I'm building a school using federal money, it comes through the state, and I either have federal contractor minimum wage, which is higher, which I think is $10.90 right now, or I have a prevailing wage. But rank and file, most businesses, if I'm a non-exempt employee, which is the majority of employees, $7.25 an hour. And I do understand that, gosh, how does someone make it on $7.25 an hour, 40 hours a week, figuratively, or less, $290 a week? That's a challenge. So the idea that the minimum wage, and I'm feel comfortable to suggest the minimum wage at the federal level for just basic employers is going to move. It simply is. Maybe this year, maybe not, who knows, but it may be sooner than later. The proposed minimum wage at this point is a suggestion of $15 an hour. Okay. Now that brings you up to $600 a week. And I'm going to talk about that in a moment. It's interesting that with the last election period, states like Florida have started to say, we're going to move towards $15 an hour. The idea has been, we're not jumping tomorrow to $15 an hour. We're going to tier it. Maybe we go up $1 a year to 2026, 2025, 2024, whatever it is. So on one side of this is the idea that I think we all agree that people that work hard, yes, we want them to make a reasonable wage to support their family. Think about the cost of goods and services sold and businesses. And so there's many businesses. It may be a convenience store. It could be a Burger King. It could be, a number of different things where people are maybe making a lower, above $7.25. And so what happens to the cost of goods and services? There's going to be an adjustment. When you go to McDonald's down the road and say, I want that quarter pounder with cheese, well, chances are it's not going to be the same price if we're paying minimum wage for 15. So there's going to be an adjustment. And that most likely is going to occur. We have to see how that's going to happen. and how it evolves. And so that is one thing to watch. And I think most businesses, I think Justin may agree, but the compliance side of things in the strategic planning, scenario planning, it doesn't mean you have to change everything overnight, but what happens to my business if I go to $15 an hour minimum wage? It's something to look at. The other thing is, whereas W-2 employees or employees, let's say, most are non-exempt. I pay you minimum wage. I pay you overtime if you work over 40. In some states, there's other overtime criteria. There are some employees that are exempt employees. And there's 5 buckets. There's executive, which is basically management, primary duty, administrative, professional, outside sales and computer. And I won't go into all those at this point. But what had happened up to a couple years ago, I'm trying to think if it was maybe 2004, maybe off on that. But anyways, there was an update in the salary threshold for someone that's exempt. Now, this is important because, you think of somebody that maybe works at a Walmart, for example, good organization, they're working 60 hours a week. What's their salary threshold, and what's that rate of pay really look at if they're working 60 hours a week? And not just looking at Walmart, any number of organizations. So we all know that the suggestion was, and the proposal was to almost double that to $913 or 47,000 and some change. Well, in the past, typical increments have been at 10%. They usually look at that southeastern United States as kind of an area to benchmark among others. And I believe that made it to really the night before of it going into law, when a federal judge in East Texas said, well, hold on, let's stop. Not opposed to people making a higher salary threshold for an exempt employee that gets a set salary figuratively. And, if they work overtime, it is what it is. You get the set salary. So that got reversed to what it currently is right now, of $684 a week. And 10% can be a non-discretionary bonus. And there's some consideration if I'm highly compensated, north of 100,000 or now north of beyond that with the current changes or their most recent changes. Think about this. Minimum wage, if I go to $15 an hour, that's $600 a week. And then I've got someone next to me that qualifies as an exempt employee, gets a set salary, he's probably working more than 40 hours a week, and they're getting, what, $684 a week? Chances are that salary basis threshold will most likely look at 913 or another number. Not guaranteed. That goes into your scenario planning. It was interesting when this was at the doorstep a year and a half or so ago or whatever, well, a little bit before that, actually, more so. But what you had was, even in nonprofits, those that were exempt, they were relatively safe. They met that threshold and so forth. Apologize for a phone ringing in my background. I've got to talk and keep it going. But it's something to watch, the wage and hour piece. And these are trends that will continue. So let's go to the next slide here. And let's talk a little bit more about the National Labor Relations Act and pro-labor agenda. All right, that's shutting off. A couple things I want to talk about. There's several things, and we'll talk a little bit more. One of which that's been a kind of a moving target is independent contractors. And a person that provides services before you get to exempt, non-exempt as a W-2 employee is either an independent contractor or an employee. I always assume employee, prove independent contractor. And there's been a state comparative, maybe 20 questions or roughly or less that says, are these questions yes or no? Do they have their own tools, profit loss? They control their own workflow, things like this. And so what had happened back in September is there was a proposal that has then been introduced. It's gone for the Federal Registry, and it's going to go into effect, I believe, March 8th, unless something changes. That said, let's make it a little bit easier. And let's look, among other things, not just these, but primarily a 2-factor test. Nature and degree of control. A very generic example. If I'm paying someone to pour a foundation, I want that foundation poured by this date per specs, whether it be county, otherwise, what have you. And they get it done. No one's over there telling them how to come and go, managing them or what have you. And is there an opportunity for profit and loss? Okay. There is something to consider here. And one of the things, I was on a great law firm like Justin's, there was a webinar, And I think, and Justin can correct me, whenever there's new administration coming in, a lot of things are in limbo regulation wise, 60-day freeze, stop where you're at, let's look at it and so forth. So I would imagine, I would venture, I take responsibility that this may in fact be put on hold. And at the very least, what we're looking at is it came out of California based on some court cases, the ABC test. And it could be adopted at the federal level or otherwise. But it expanded a little bit and talks about the control and direction being provided. Is it outside the usual course of business? If I'm making widgets and you're coming in to make widgets alongside an employee, well, you're kind of, it's an integral part of the business. Versus I'm coming in to provide a complementary service that's really not part of what you do as far as service and products. And is this an independently established trade? So the point of this is, this has been a target. I've mentioned I've had a couple clients that are working with good intentions. We've had challenges by the TWC, Texas Workforce Commission, when someone filed unemployment, answered honestly, and we were okay. But what I'm understanding is moving forward under the new administration, it may be harder to identify and classify someone as an independent contractor. In the past, I'm not sure that's still the top initiative, and we'll talk about a couple of things here in a moment. Watch my time here. You know, there has been, you know, some consideration there of watching those sort of things. And so again, we need to be very, very careful in our planning. And so with that, let's move on to the next slide. There's something else I want to share, and then we'll go into some of the trends that really are the big three agencies, the EOC, National Labor Relations Board that we're talking about here, and then Department of Labor. And so the National Labor Relations Board, and Justin, you may remember better than I think the National Labor Relations Act, 1935, but it really kind of set forth and said, look, workers can gather. And they can gather and say, gosh, you know, we'd like to have reasonable wages, reasonable levels of protection, things like this. And I don't think anybody was necessarily against that. It's fair. But where we've had a non-aggressive past administration on the National Labor Relations Act and the board that governs that, we're starting to see a swing back, as I mentioned, towards pro-labor. And so, you know, there's a couple things here. This was from a webinar the other day, and I like these 3 bullets. Check the abuse of corporate power over labor and hold corporate executives accountable for violations of labor laws. And so, I apologize, I'm not off this phone. So that's kind of the mindset. Now, that's interesting. In states like California, an HR professional can be held liable. Okay. And civilly, maybe even criminally if they're intentionally negligent. So now that puts more of a responsibility on leaders of an organization to say, are we doing the right thing? Encourage unionization and collective bargaining. So there may be more of a lens towards organizations, particularly federal contractors, say, are you encouraging open communications? Well, I want people to have fair wages and so forth, but I don't necessarily want to go out there and encourage everything. Or maybe you have a different mindset. I don't want to get into the left or right of that, and that's not political. And ensure that workers are treated with dignity and receive the pay, benefits, and workplace protections. Well, that in itself sounds great. But what we may start to see is a little bit more of what would be called quick elections that say a group of employees can come together. Okay, that's concerted activity, or coming together, and it's protected. We're talking about work conditions, things like that. And maybe they don't have to go through some of the same formality to come together, talk about these, and move through maybe what they would call quick elections. So do they have the opportunity to move more quickly towards unionization? In my mind, where you may start to see these things continue, at least when it comes to our area. And the north and some of those areas are a little bit different. I have family back in Connecticut. And if you want a plumber up there, you get in line with a union plumber, and they get out there when they get there. And I mean that with respect. But you're going to start to see that trend. So think of COVID, Amazon, food service workers, grocery store workers, healthcare. What are those big groups that say, hold on, are we getting meaningful pay to deal with a hazard per se? The other thing is the Taft Hartley Act. Now, this was an amendment, I believe, in 1947 or at or about, that came out of a lot of talk between 45 and 47 that said, unions, stop a little bit, hold up a little bit. We don't want you to have too much control. And that may be left up to interpretation. But what's interesting in this, and we'll see what happens, is there going to be an effort at the federal level perhaps to repeal Taft Hartley? What does that mean? Well, that may mean such as with Texas. Texas is a right to work state. I have the right to work. Does that now mean that if I'm a plumber in Texas down the road that I have to join a union to provide plumber services? As one example. I think that's going to be a little of an uphill battle, but we'll see. It's part of that pro-labor agenda. A few things there. Let's go ahead and go to the next slide, and we're coming close on time. One last thing, we'll move on to the big three and kind of close it up and look for any questions. Justin mentioned some things about OSHA. And it was back last year. I don't remember if it was the fall or which have you, but OSHA came out, or some conversation came out about OSHA. Are you doing enough to enforce workplace protections, remove that general duty clause, identify and remove hazards? And so with that, I think at some point, there was a number of maybe 85 citations issued. And so the pressure became on OSHA to say, are you doing enough? OSHA's come out with some guidelines for workplaces and so forth, better ventilation, obviously PPE, a lot of different things. But there had started to be some lawsuits in this area. So I am not here to suggest that there's doom and gloom, depending on how you look at it. But I would suggest across the Department of Labor, EOC, OSHA, and otherwise, you're going to see the hiring of a lot more compliance officers and a lot more audits and questioning, are you doing enough? So something to watch there. And I think the basis of that, and Justin may agree or disagree, but I would imagine maybe agree, if you look at your organization, do you feel comfortable? It wasn't always that you could, take somebody's temperature at the door. And that may not be the case always, neither, moving beyond COVID-19, but some of those things have changed. Are you having a self-declaration form filled out that I don't have any of these symptoms? Are you taking temperatures, requiring people to wear, a mask or what have you if they're not able to social distance? What are you doing as an organization, at least in this period of time, until things change with the vaccine or what have you, to say, look, I'm acting in good faith and I'm doing things within reason. And like with the state of California, which is very aggressive, I think it's if you have 3 or more cases within 14 days, you have to report it to the Department of Health, you report it to your carrier. So there's some increased considerations there. We'll see. I think more than anything, OSHA will be out there following up on potential workplace exposure, which is hard to identify, but there's a consideration of reason that folks got it at work, and well, that may be where you got it. So something to watch in the interest of time. Let's move on to the next slide, and we'll talk about a few things, kind of, again, the big three, if you will. And so labor relations, National Labor Relations Board, again, we talked about that. We're looking at a very pro-labor environment that's been suggested, a Secretary of Labor that may get appointed, if not this person, somebody else. So independent contractor, harder to classify. And really the issue there is 2 things. An independent contractor, they may be paying their own taxes. But if you get audited and you have someone misclassified, the IRS is going to say, I'm fine, Justin paid his taxes. Where are the taxes from you as the employer? That doesn't count. And would they have had maybe the opportunity to participate in health insurance, whereas they're misclassified and they didn't? So there's things to look at there. And again, a pro-labor environment. Most importantly, I think that's going to happen primarily at the federal level. And if you want federal contracts in the future, the suggestion is you may want to take that position of I'm supporting unions. I'm not saying you have to. I'm not saying that's the way to go. But there's some suggestions, there's things tied to that. And you just want to be thoughtful and monitor that and see what the temperature of the water is. Let's talk real briefly about one of the main things that I want to hit on as we close, the Equal Opportunity Commission. Now, keep in mind your EEOC laws that say we prohibit discrimination and harassment, retaliation, or forms of discrimination apply to employers with 15 or more employees. I think we would all agree if you have less than 15, you still want to be fair and equitable to people, but it becomes a little bit more defined when you have 15 or more. So really 5 top objectives. Equity, racial equity. And so what we may see there is we've seen a lot about equity audits within the school district and otherwise. And so businesses, schools, otherwise. That's been in place with the EOC for a while in my mind. And the idea is, do you monitor for disparate impact? That you have a policy, a hiring policy that whether maybe it's unintentional, most likely it is, but for some reason it seems to disproportionately affect individuals of a certain race. And there was a classic case out of New Haven, Connecticut with individuals wanting to become fire chiefs. And it seemed that your African-American candidates or Black candidates, what have you, were somehow not getting through. And so it brought up a question, is there systematic discrimination? Is there something within your policies, intentional or not, that's disproportionately impacting people from fair opportunities? Okay. Second of 5 buckets, LGBTQ. This is an area that the new administration says we want to be a little bit more aggressive. And so I know in the past, I'm trying to think back, I was thinking earlier, maybe it was a couple years ago, but the EOC was really focused on pregnancy and one other protected class. And so they were looking at all of them. But when they had the one that was progressive in terms of pregnancy or some of these other areas of focus, they were really digging in. So this could be an area, not that any of us would be discriminatory or not be fair and equitable, but we want to be careful. Do we have the right practices? And if we have a policy that has some consideration, well, what's it based on? Is it based on some personal preference, which probably doesn't play into it, or some business legitimacy? Equal pay. And this has been going back to Lily Ledbetter, which was an actual lady out of, I believe it was Alabama, worked in a plant, and I forgot how many years, but a couple decades, and near termination, somebody said, hey, Lily, do you know you've been getting paid a lot less than your male counterparts for doing a similar job? And so what we're most likely going to see there, among other initiatives, is employers with 100 more employees, which may not be those on our call today or Zoom presentation, in addition to an annual reporting of classifications, executive, administrative, laborers, unskilled, what have you, that the EOC sets forth, looking at the demographics in terms of race and gender. What we're most likely going to see, probably another year out, because the new reports are going to be coming up in April, is with those classifications in terms of executive, administrative, what have you, race and gender, what salary brackets or compensation brackets do these individuals fit within? You don't have to pay everybody the same as long as you have a non-discriminatory reason. And so we're right here near the end, so I'll wrap it up. Sexual harassment, the Me Too movement is still there. And so this may be an area that EOC starts to initiate litigation and be more aggressive. And then age. And so they're going to look at whether there's a motivating factor. The last 2 things I'll share as we come to close here in interest of time. Department of Labor, we've talked about a lot of things, minimum wage, Fair Labor Standards Act in terms of salary threshold. But as we also mentioned, the new administration comes in, anything regulatory is kind of right there on the burner, just like the independent contractor 2-factor or 2 core factor consideration. Stop. I want to look at that for 60 days. Now, there's another suggestion which may come into play or not, that if you have an overtime violation or minimum wage violation, we may double those fines. So let's stop there. We're right at 1, if not a minute over. So I look to Paige primarily if there are any questions in chat. I also want to thank Justin, who's just a tremendous resource in our community and beyond. And I always look to his firm and himself as a resource, among others. And I think this is important. Justin's been very kind to provide his information here. I've known Justin for some time, and like any of us, have to take care of your family. But he is the type of person, I believe, that will always look out for somebody, try to answer some basic questions and guide you from there, as I am. So with that, we'll conclude. I'll turn it back to Paige and King. And please reach out anytime you have a question, and we'll try to guide you appropriately. So Paige, King?
Yeah, I'll take it from here. Mike, Justin, thank you so very, very much. I mean, incredibly not only informative, but insightful information. Unfortunately, we are running short on time. There are a number of questions. So what I'm going to ask those that are in attendance right now, if you still do have questions, go ahead and type them in the chat or in the comment section for the Facebook Live component of this, or you do see both Justin and Mike's contact information here on the slide. Feel free to email them directly. And one last one I'll make mention of, if you want to email Paige at the email address that's on the website, we'll make sure to get answers to your questions. I will say this again, as I mentioned to you both privately, I'll do so again publicly. Information in these sessions have been instrumental for a number of us in understanding both the law and best practices as we all navigate through some pretty unprecedented times. So guys, thank you so very, very much. As we wrap up today's sessions, let me make you aware of just a couple of upcoming events for the attendees. We have tomorrow the Payment Protection Program Round 2 with the SBA Houston District Director, Tim Jeffcoat. And that's tomorrow, February 4th from 11 to 12 p.m. That will again be a Zoom webinar. On the 19th of February, we have the 2021 State of the City Sugarland presentation, and that's going to be with Mayor Joe Zimmerman and Michael Goodrum, who is our city manager. That will also be a virtual presentation. And so if you're interested in joining any of these upcoming webinars, please view the chamber calendar at fortbendchamber.com, and you'll get all the details there to register. Thank you all very, very much for tuning in. Have a great day. It's beautiful outside. Really appreciate your time. And again, thank you all.
All right. Thank you, everybody. Have a wonderful day.
Thanks.